I'm very, very pleased to welcome Jeffrey Cunard tonight to our series on open source culture, exploring issues in intellectual property, technology, and the arts. I've known Jeffrey since the spring of 1996. I had just moved to New York City from Berlin and started an arts organization called Rhizome, and I realized that I didn't know as much as I needed to know about starting an arts organization, and that I should probably talk to a lawyer. So I was very lucky to meet Jeffrey. Jeffrey then worked with us on a pro bono basis for several years, eventually joined the Rhizome board of directors. Jeffrey is also on the board of directors of several other arts organizations, including the College Art Association and the Freer-Sackler Museum, which is part of the Smithsonian Institution. He's chairman of that board. Jeffrey is a lawyer. He's a partner at the law firm of Debevoise and Plimpton. His specialties are intellectual property, information technology, arts, media, and communications. He is the author of a few books, most recently Copyright Law, Practitioner's Guide, and I think partly through his involvement in various not-for-profit arts organizations and partly through his own enthusiastic interest, he seems to know quite a bit about art. So I'm thrilled tonight to be having a lawyer talking about intellectual property issues and other issues in arts. Please welcome Jeffrey Cunard.
Thank you, Mark, for that very gracious introduction. It is unfortunately the case that I am a lawyer, and this is one of the few times that I'm at Columbia not recruiting at the law school. So for me, it's a great pleasure to be in front of such a distinguished gathering of non-lawyer law students. What I want to talk about for about an hour is the intersection of art and art making and law making, and ask whether those worlds collide in an open source contemporary art practice environment in which we find ourselves today. And I hope that will be of interest to you. I will be here, of course, at the end to answer any questions that you might have. This is not the name of the case, or any case, but it does sort of summarize what some have characterized as the sort of antagonism or the relationship between the artistic impulse on the one hand and the strictures of the law on the other. And indeed, I have myself sampled that case name from this statement of principles, which I think is worth exploring this evening. I was inspired by Joy Garnett's lecture, the first in this series. Some of you may have been there for it. But today I want to build on that lecture and tease some of the applicable legal principles out of the situation in which she found herself, and focus on how art and the law deals with the kinds of contemporary practices in which she and so many other artists today are engaged. In her talk, in one very pithy sentence, Joy summarized much of art making by saying it is about the freedom to sample and appropriate. That's part of the creative process. Artists, as we all know, sample and appropriate from the very rich visual culture that surrounds us, whether it's the work of photojournalists, as was the case with Joy, other artists, commercial content owners, record companies, movie studios, writers from the public domain, from iconic images, from pictures of celebrities, whether or not those images belong in some sense to others or not. This open source kind of art making is really an inevitable part of today's contemporary art practice. But as we shall see, it is not only contemporary art practice, but one that distinguishes the history of art making through the centuries. Now, in the last month, an influential court of appeals in a digital sound sampling case said, well, if you cannot pirate copyrighted work, you can't lift it, and you can't sample it. You cannot take anything, even some minute portion that's less than the whole, and in memorable words which are now redounding through the sort of art making and legal community, the court said, get a license or do not sample. We do not see this view, this bright line rule, as stifling creativity in any way. Sampling is never accidental. You are taking another's work, period. Now, of course, the law itself and other courts are much more nuanced in the way they grapple with these problems. But nonetheless, the fundamental issue remains, is appropriation, open source art making, in inevitable collision with the law? And the answer, as we shall see, or at least it's my view, is not that there is in fact an inevitable collision, but that at least some type of art making does occasionally get into the legal scrape, the fender bender, if you will, though occasionally there are even more serious injuries that occur. Let's start with a preliminary matter. Courts grapple with the complex questions of what is art and how the law should treat art all the time. It's not really a contemporary post-war phenomenon. In the United States, courts have addressed this question of what is art since at least the 20s in a case involving this wonderful landmark abstract sculpture, Brancusi's Bird in Space. The sculpture was seized in 1927 by the US Customs Service, which sought to impose a tax on raw material. After all, from the standpoint of the Customs Service, this was just a hunk of metal. Customs refused to grant Brancusi an exemption applicable to original works of art. They said, hey, this isn't art. Now, Brancusi filed suit to have the work declared an original work of art, and indeed, the following year, in 1928, the court granted this sculpture the official status of a work of art. So not all courts, in fact, are as Philistine as my opening might have suggested. Now, to move into the meat of the subject, makers of art, and perhaps courts, or at least lawyers who do battle, may have to distinguish between different types of art-making practices. This evening, I myself want to distinguish between what we call illegitimate art-making and legitimate open-source practice. And the initial cut here is between, let's say, what we call forgery and plagiarism on the one hand, and appropriation or sampling on the other. And then, having drawn that distinction, I want to proceed to identify differences among the various types of appropriation and why those differences may matter in the application of certain legal principles, essentially copyright, trademark, and the individual right of publicity. And then finally, at the end, if I have time, I want to turn to some special problems posed for publishers of art and possible avenues for addressing these problems. Now, in some sense, as we know, all artists are open source. Every artist borrows from and stands on the shoulders of those who have gone before. And I will turn in a few minutes to the different kinds of borrowing practices that we see, from rote reproduction to variation to highly transformative adaptations, and finally to drawing in artistic inspiration in terms of style and idea from people who have practiced art before us. But while these are all variants on kind of legitimate artistic art making, let's first try to focus on what is forgery and plagiarism and how does it differ from this kind of appropriation. Forgery in the law is an intent to deceive, usually for financial gain, by offering an art object as representing something other than it is, while appropriation, at least for purposes of this lecture, will call the use of a pre-existing work, the modification of that work in some way, creating a new work, albeit one that may be very, 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 very close, if not identical to the original. So here we need to take cultural differences in the evolution of artistic practices over time. The tradition of artistic inspiration, rather than of clear-cut cases of forgery, is perhaps most ingrained in classical Chinese painting. Southern Sung painting inspires Ming painting, and Ming painting is the inspiration for late Qing painting, but the line is blurred. Indeed, a famous Chinese scholar, Zhenzhou, himself wrote, "If my poems and paintings, which are only small efforts to me, should prove to be of some aid to forgers, what is there for me to grudge about?" Well, let me start with some images from that Chinese tradition. As Mark mentioned, I have the honor and the privilege of being involved with the National Museum of Asian Art, the Freer-Sackler Galleries in Washington. A couple of years ago, we had an exhibition of the works of Bada Shenren, a Qing dynasty master principally working in the late 17th century. His favorite themes were flowers, birds, fishes, and his paintings were known for a flat, angular brush stroke and the technique of layering ink in a particularly specialized way. Now, 3 of his paintings, and actually many more, were forged in the 1930s by Zhang Dongquan, who was one of the greatest traditional Chinese painters of the 20th century, and a major forger of this fellow's works. His forged paintings bear the signatures and seals of Bada Shenren. He replicated almost every aspect of the original, but he altered some elements, and his forgery was revealed only through a comparison of brush strokes and his use of ink. Now, I'm going to run through 3 of these, and we'll see if any of you can tell the original from the forgery. Hard to tell, I suspect. Well, the ones on the left were the originals. Now, what makes them forgeries and what distinguishes them from legitimate artistic appropriation are the elements of deception and fakery, right? This strikes us as not legitimate artistic appropriation. It's simply not right. But if copyright law were applicable, and it is not, these would be reproductions, or at least derivative works, and as such, if Bada's works were not in the public domain, he or his heirs could probably have sued Zhang. Now let's take a look at another example of forgeries, this time from works that may be a bit better known to you, involving one of the greatest painters of all time, Vermeer. First, let's look at a couple of originals. This is an original. That's an original. But now let's look at a couple of forgeries. These were forged in the middle of the 20th century by Hans van Meegeren, a Dutch artist who specialized in forging Vermeer. He was convicted of fraud. He died a few weeks after his trial in 1945. Would Vermeer's heirs have had a right to sue for copyright infringement, again, assuming hypothetically that these works were not in the public domain? Well, maybe not, because van Meegeren did not, in fact, copy any actual expression of Vermeer. There was no literal reproduction in toto of any single Vermeer work. And so this raises the question of, can an artist protect his style as opposed to the literal expression or images he creates? And we'll turn to that in a few minutes. Having now talked a little bit about forgery and plagiarism, let's focus on artistic appropriation itself, which is the meat of the talk. As Joy Garnett's experience begins to illustrate, for those of you who heard her, open source art making may run afoul of the law. She made a painting from a photo taken by a photojournalist some couple of decades before, and received a threatening letter from the lawyer for that photojournalist, Susan Meiselas, which spawned an exchange of some intensity and joy war, including an active discussion, I believe, on Rhizome. Let's talk about the different types of artistic appropriation that we might be examining today. First, there's artistic inspiration that relies on themes and composition. There is then transformation of the original. Essentially, you take an original work of art and you transform it. There are 2 types of this transformation. You modify the work itself. You do something to the actual work, or you don't do anything to the actual work, but you somehow recontextualize it. And finally, there's literal copying, copying without more, calling a copy one's own, a classical postmodern practice, but not, of course, a forgery. Now, on this spectrum, the risk of collision between art making and the law would seem to increase the further along the spectrum one goes, with the maximum risks raised by literal copying. Well, why is that? I'm going to spend just a couple of minutes on copyright law because I suspect there are not a lot of lawyers or law students in the room, but let's just recap for a moment the essentials of copyright. Copyright gives the artist or other copyright owner the exclusive right to reproduce the work. There can't be any unauthorized copies or substantially similar works. The exclusive right to adapt the work, so you can't make a photo or a film of a sculpture. You can't make a sculpture from a photograph. You can't make a painting from a photograph. Gives the copyright owner the exclusive right to publicly perform the work. It's important to understand, this is very important in the museum world, by the way, that the ownership of the physical copy is not the ownership of the copyright. There's a distinction between the copy and the copyright. The owner of the copy can do with the copy what she wishes with it, but can't do anything that implicates the copyright owner's rights absent permission or fair use or some other exception in the law. And finally, no one can exercise copyright over ideas as opposed to expression. There is also the notion that copyright is a strict liability statute. Innocence is no defense. Good faith is really no defense. But But there is a fair use provision, which we'll get to in a moment, that at least for artists can be a significant limitation on the exclusive rights of the copyright owner. This safety valve was the subject of some discussion by Joy. But before I get to the discussion of fair use, I want to talk a little bit about the difference between style versus expression, which I mentioned a moment ago. Because as I said, a copyright owner has no control over his or her artistic style, only over the expression of that style. Let me illustrate this with an example drawn from two works of Christo. Christo's wrapping of the Pont Neuf was world famous, of course. Two news companies had used photos and films of the wrapped bridge taken without Christo's authority. He sued, and the court found that the artwork was in fact original expression. The idea of accentuating the pureness of the lines of the bridge and its lamppost by means of cloth and ropes was an original work eligible for protection. But Christo then sued an advertising agency which had disseminated photos of a swimming pool covered in pink cloth, presumably contending that the idea of covering water in that material was an infringement of his well-known work in Biscayne Bay, illustrated here. The court denied him the relief, saying that the law only protects creations of particular individualized objects and not a category or family of forms that have features in common, only because they are part of the same style. Christo could not protect this idea of his. What he could protect was the expression of the idea. Now, let's turn back to fair use, because much of the rest of the talk will depend on an understanding of the nuances of fair use and how it might come into play. This is variously the client coming to the lawyer going to the Copyright Office, or some other variant, because, in fact, no one really has any absolute certainty as to what is fair use, and there's the rub. Fair use, as Joy explained, is a doctrine built into the copyright law. For those who weren't at her lecture, here's another 30-second recap. Fair use can permit appropriation of works for certain purposes, such as scholarship, criticism, teaching, or reporting. There are factors that courts take into account, and we'll talk about some of them this evening. One is the purpose and character of the use. For artists, this is one of the most important of the factors, because the key here is the work transformative? The more transformative the work is, the more likely it is to be a fair use and therefore fall outside the exclusive rights of the copyright owner. And that's probably good news for most artists working in today's contemporary art practice, because most of them are transforming the work that they're taking in some fundamental way. Another factor, which is identified at the bottom of the screen, is the effect of the use on the potential market for the original. The more likely that the work is to be transformative, the less likely it is to have an adverse effect on the market for the original. And we'll go through some examples of that today. So at least with respect to copyright law, we have some perspective on when open source appropriation might not be considered a fair use and therefore fall within the exclusive rights of the copyright owner. First, let's talk a little bit about artistic inspiration. And because there was one slide there of legal principles, and now we have to get back to looking at art. Let's start with the most famous sequence of artistic inspiration, which is based on an etching of a lost drawing by Raphael, The Judgment of Paris. And this was the inspiration, as we will see, for painting by Manet to paintings by Picasso. And relating this story, I should say that I'm indebted to an essay by Karsten Schubert called Raphael's Shadow on Copying and Creativity, which appears in Dear Images, Art, Copyright, and Culture. Marc Antonio Raimondi had copied Raphael's The Judgment of Paris, which had been held in very high esteem by much of Rome. He did so because he was employed by Raphael, and he copied the drawing with the artist's consent. If he had not done so, that would have been copyright infringement, had that been a cause of action back in the 16th century. Raphael is lost. The etching is the only first-hand record of Raphael's work. And I want to focus your attention on the grouping in the lower right-hand side. It appears, with respect to this grouping, that Raphael himself at least as to this aspect of the composition, had been inspired by an arrangement on a Roman sarcophagus at that time in the Villa Medici in Rome, and I say, hey, this is a fair use. Here's a close-up of that composition. Manet turned to the Raimondi print, as Raphael was considered at that time the greatest master in painting and in drawing. He made the figurative group at the periphery of Raphael's composition the center of his own. In this very famous painting, a scene from purportedly contemporary life in 19th century France, Le Déjeuner sur l'herbe. Of course, the painting caused an outcry due to its shocking subject matter for any of you who've taken Art History 101. Now, is that a fair use? Well, I'd say so. Now, Picasso saw Le Déjeuner in Paris in 1900, and his Demoiselles d'Avignon in 1907 are a direct reference to the painting. He eventually acknowledged the relationship between the two paintings, but I'd say that they're sufficiently different, Picasso being sufficiently transformative here. It's definitely a fair use. Now, later on, in the middle of the 20th century, Picasso began his Déjeuner series. And in June 23, 1961, he drew this scene. As Ms. Schubert, the author of the essay, describes it, a dramatically foreshortened woman bending forward and gathering up her chemise, a suited man with hat and walking cane, seated in profile against a tree. And Manet's painting is the obvious source for this composition called Le Déjeuner after Manet. And what do we think? Well, it's highly transformative, right? Even though it's clearly appropriation. Let's turn then to, from artistic inspiration, the borrowing of themes and so on, to transformation that's a kind of addition. That is, you take the original, but you add something to it. Here's some images drawn from contemporary art making. The Japanese artist Morimura is known for taking old master paintings and painting himself into the picture. And leaving aside the fact that the underlying works are in the public domain, it seems to me that this form of highly artistic transformation would seem to be fair. So some of you may recognize this painting by Caravaggio, Bacchus, but certainly no one would think that this Morimura riff on the Caravaggio original would displace the market for the original. At least I don't think so. Or let's take Olympia, and no one would think that this again is displacing the market for the original, assuming that there were such a market. Now, before I move on from painting to sort of new media, let me talk about the special case of photographs and indeed other new media such as motion pictures and video. Photographs were really in some sense the first new media because paintings and sculpture were around for hundreds if not thousands of years, and they've posed special challenges for lawyers and lawmakers. One of the challenges of photographs is that they capture reality in a very obvious way, and the photographs can be made quickly, easily, and cheaply, and fundamentally they can be easily reproduced and readily appropriated. Now, as Joy herself learned, photographs are a separate species of copyrightable work. Whether or not the underlying work, the work that's being photographed, the Statue of Liberty, a celebrity, your best friend, another copyrighted work, a Molotov bomb thrower, is itself the subject of copyright protection. There's one significant exception to this principle that photographs are copyrightable, and I'll talk about that at the end. Now, should photographs be copyrightable? Good question. John Ruskin wrote in The Stones of Venice in the end of the 19th century, a photograph is not a work of art, though it requires certain delicate manipulations of paper and acid and subtle calculations of time in order to bring out a good result. And we'll see that, as I say at the end of the lecture, echoed in a decision of a few years ago here in New York in the case involving the Bridgman Art Library. But in 1869, just a few years later, the British courts held that photographs were indeed copyrightable, and that's the rule in the United States. I've lingered here to discuss photographs because the next set of images involves photographs in other new media, and because it seems that photographers are among the most proprietary of copyright owners, as Joy found out. Painters really seldom sue painters who appropriate their paintings. But photojournalists seem more likely to sue, and I've given some thought as to why that might be the case. Well, it may be because that's the way the industry is structured. Photojournalists just are a more proprietary breed and depend a lot on the sale of their images. It may be because they have less sympathy for artist appropriators, although I don't think that's the case. But it may be because a copy of a photograph, like a copy of a movie or a copy of a video or a video game, substitutes so immediately and so directly for the original, unlike a copy of a painting. And that's what seems odd about Joy's experience. There's no question that Joy's painting of the photograph was in no sense really a substitute for the original. Let's return then to some of the types of appropriation. I don't know how many of you would recognize this image. This is taken from the work of Paul Pfeiffer, who manipulates video art and video images to make new video works. He too samples from historic, moving images, whether from sports or the world of entertainment. He uses iconic images of heroes to look at questions of identity, not a hero in this particular example, and historic events. His idea is to sort of decontextualize moments in time and then recontextualize them in his own artistic practice and look at the influence of technology on art making. Now, does anyone recognize this? That's right. But this is a work by Paul Pfeiffer called The Pure Products Go Crazy, a 2-second loop of basically an unrecognizable Tom Cruise in his tighty-whities humping the sofa from Risky Business. Now, he doesn't always use movies. This image, which is hard to see, is from Long Count, a video triptych based on Muhammad Ali's fights against Sonny Liston, George Foreman, and Joe Frazier. What he does is he removes the key figures from the events, including the boxers and the referees, leaving a looped image of the crowd. Here's another excerpt from a digital video loop called Goethe's Message to the New Negroes, number 1, number 2, and number 3 from 2002. And again, he's appropriated perhaps significant images without the permission of the copyright owner. Although it is interesting when you see this image on a website from which I took it, it says copyright the artist. Another one, it's a digital video loop, corner piece from 2002, features footage of a boxer being treated in the corner during a match. It creates the effect of, as you can see, infinite spatial recession, as if you're sort of putting two mirrors across from one another. And finally, Live Evil, another video installation of his, the artist morphing the dancer Michael Jackson. Here he splits Jackson in half and reflects the image in a kind of Rorschach-like way. Now, all of his manipulations seem, at least to me, as highly transformative as fair uses. Well, let's talk about another artist who's been accused of scene stealing and worse. John Ralston, a Baltimore-based artist, takes video cameras into movie theaters and points the cameras at the screen, just like pirates do. And the New York Times last year wrote a story about bootleg film and videotaping, noting that Ralston himself makes art that tackles the practice of bootlegging. He takes the digital video that he's shot, he converts it to MPEG, he burns the movie onto a DVD, and this is a kind of format conversion. It's a transformation, is it not? Or is it really bad, bad, bad? Now, in an interview, Ralston himself said, I guess it's theft. And others may agree with him. For example, one writer, Jerome Dubois, says, let's be clear. Mr. Ralston illegally snagged a copy of a complex artwork which cost blood, sweat, tears, time, and money, none his, then sat on his ass in front of his technology and cut apart a piece of work he couldn't conceive a thousandth of on his best day. Now, this is an excerpt from commercial break stills from Ralston's Cremaster, which is the edited for television version of Matthew Barney film Cremaster 4. Now, it may be that because Ralston is appropriating the work of some other iconic artist who is quite popular and well known, that this has aroused the ire of others in the artistic community. Now, what is in fact the difference between bootlegging and what this artist does? Does it in fact make a difference because he exhibits the works in galleries and that he doesn't sell his bootlegs on the cheap in substitution for the original? Is this a kind of recontextualization? The space in which the art itself experiences, does that somehow fundamentally alter the work? And we'll talk about that a little later when we focus on Douglas Gordon. The issue is not resolved. What is resolved, though, is that his art-making practice is illegal because it is a felony in New York, California, and elsewhere to go into a movie theater with a video camera. And it's soon, if Congress has its way, it will be a federal law violation. Well, it will be a felony under the Artist Right and Theft Protection Act, which Congress is on the cusp of enactment. Now, he doesn't always go into movie theaters and shoot the entire movie on a video camera. Here, in stills from his Kerry Porky's Originality, Neatness, and Hygiene, he has manipulated images from 2 shower scenes from 2 movies. So there is, in fact, a recontextualization and transformation of the work, not unlike Pfeiffer and, as we'll see in a moment, Christian Markley. And what about another kind of appropriation, which involves media conversion? That is to say, in this, either from a painting to a sculpture, or from a photo to a painting, as Joy Garnett did, or in the case that I'm about to show you, from a print to a painting. This is not really rote or slavish copying, but is infusing the original with the artistic sensibility and the style of the appropriator. Here is a print from one of Hiroshige's 100 famous views of Edo, called The Plum Garden at Kameido. And here is a remarkably similar painting by Van Gogh. He painted his Japoneserie in 1887, and this is indisputably a copy, although with some, indeed quite a large number of original elements, not to mention stylistic differences. But Van Gogh, like many other master painters, was a famous copyist. He copied Rembrandt, Delacroix, Daumier, and he gave no thought to copying the Hiroshige, aside from the fact that it was in the public domain. Now, would Van Gogh's copying be copyright infringement today? Again, in my view, given the transformative nature of this painting, this ought to be regarded as legitimate artistic practice and within the bounds of fair use. Now, another kind of appropriation is appropriation by incorporation, taking the entirety of the work and sort of putting it in a different context. As Mark mentioned in his introduction of Joy Garnett, artists have been making collages for a very long time. Picasso, Braque, and Gris put found objects into their collages, and no owner of the newspaper or the placard or billboard ever sued any of them, at least so far as we know. And also, I should note, going back to one of our sort of elemental copyright principles, it's in fact not a violation of copyright law to take an actual object, a newspaper clipping, for example, or a sketch of an artist, and put it into another work. What is potentially a copyright violation is when that is the second work is reproduced, either in a catalog or in prints or filmed, because then you're making a copy of the artwork that's incorporated. Here's an example taken from a real live case. There was an artist, Lebbeus Woods, who'd created a pencil drawing entitled Neo-Mechanical Tower Upper Chamber, depicting a high-ceiling chamber, a chair mounted into a wall, and a sphere suspended by a metal frame. It was published within a copyright compilation of his drawings in 1992. And for extra credit, does anyone recognize this? That's right. So in 1995, Universal City Studios released the movie 12 Monkeys, 10 points to Columbia over here on the left-hand side of the room. And in this opening scene and in subsequent scenes, they use this clear derivation of Woods' drawing. So what happened? Well, the court rejected the argument that this was a de minimis fair use and found in favor of the artist. Similarly, with respect to this quilt by the artist Faith Ringgold, HBO and BET aired a television program which had in the background this quilt used in whole or part for about 26 seconds. Ringgold owns the right, the High Museum owns the original. Ringgold brought suit, and guess what? She won. The court concluded that the instances in which the poster were visible were not trivial or de minimis. The court rejected the argument that there were no protectable aspects of this highly distinctive artwork that were discernible. The defendants had said, well, all that you really can see on the screen is some vague, stylized painting that includes black people. And the court responded, that is about like saying that a videotape of the Mona Lisa shows only a painting of a woman with a wry smile. Now, query whether the case would have come out differently if it hadn't been sort of HBO and BET, but if it had been an artist, a painter, who had made a transformative painting of this image. Rauschenberg, unlike Braque, Gris, and Picasso, has been sued for the practice of incorporating objects into his artwork. In 1976, a photographer, Morton Beebe, discovered that his photo named The Diver had been incorporated into a Rauschenberg print, not this one. Beebe was upset because Rauschenberg was a proponent of artists' rights. He sued Rauschenberg for $10,000 in profits. The matter settled with the photographer accepting $3,000, a copy of the print, plus a commitment that if the print were ever exhibited, he'd get proper credit. Now, Rauschenberg's use, in my view, was clearly transformative. But because he'd used the entirety of the work of a living commercial artist, he did, in fact, have some litigation exposure. Now, are any of the people in this room actual practicing artists? 1, 2. So not a big group. But lest you think that you could be immune from suit just because you may not have the fame yet of Rauschenberg, let me remind you of a case that was brought right here in New York involving a student who had her work, a collage, displayed at the Whitney Museum. She'd incorporated 8 images that were copies of photographs from Living with the Enemy, a book of photographs documenting domestic violence against women. The photographer was a prominent photojournalist named Donna Ferrato. The collage was shown at the Whitney in a show, The Subject of Rape, where it was labeled an original work of art in the catalog of the show. The artist was sued. The defendant argued that her use was fair, and the case was never brought to adjudication, to judgment, because the court urged that the party settled. And in this case, the photojournalist ended up dropping the suit. More or less what had happened in some way, shape, or form with Joy Garnett. When sort of push comes to shove, the plaintiffs decided not to go forward. Another case involving incorporation and modification of a photo arises out of a suit brought by Thomas Hepker, who's a well-known German photographer. He sued Barbara Kruger and artists, who's an artist, and galleries and museums for copyright infringement. She'd created a work by cropping and enlarging the photographic image and then silk screening it and superimposing these 3 red blocks which say it's a small world, but not if you have to clean it. The work was displayed, prints were sold, and the work was used in advertising. Kruger was found to have infringed Hepker's work, classic form of appropriation. She used the work, she modified it, and clearly what was in the court's mind here was that there was an obvious and widespread commercial exploitation of Hepker's photographs. Now, let's turn again to somebody who's working today. Appropriation by incorporation, assemblage of sampled or mixed clips into a montage, is among the principal modes of the open source contemporary artist. I'm going to show you a few clips from Christian Marclay's Video Quartet 2002. He's focused his artistic intentions on retransformations of sound, vision, music, and performance, and this work is propelled by the relationship between sounds and images, what we hear and what we see. It's a 13-minute musical composition, 600 separate film clips, 4 simultaneous channels projected onto a 40-foot-long screen. This was commissioned by SF MoMA and the Museum of Modern Art in Luxembourg. It represents a very important step in new media art because of the way in which this work was created, which I won't go into today. But what Markley does say about the work is it's all about manipulating fragments, creating a new narrative, really the subject of this talk. He used a database of clips. He constructed whole scenes by stringing the clips together. And it was a very challenging task. It's undoubtedly a highly transformative work. He juxtaposes images at the same time, he combines images with sound, and he combines the bits and pieces over time, that is to say the length of the film, to form a narrative. If you watch this, you'll see and hear that includes Jimi Hendrix on guitar, and Ella Fitzgerald, Thelonious Monk, Maria Callas, Elvis, Sinatra, the Sex Pistols, and many, many more. Since the late 70s, Markley has engaged in auditory sampling, essentially sound collages. This is from another video work, which I'll talk about in a moment. Historically, he's used skipping records, loops from records. He's broken records up and reformed the fragments to create new records, which he's then played on multiple turntables. All highly transformative work, really a massive recontextualization of the original. And I would argue that sort of appropriation is very, very, very unlikely ever to subject him to an action for copyright infringement. But is the law's collective response, as we heard from at the very beginning of this talk, get a license? Well, I think not, because getting a license for someone like Markley would be a highly complex, very daunting undertaking, which in point of fact, probably would pose an insurmountable obstacle to this work being created. And that would be true, I think, for a lot of new media artists. This image is from a work of his called Telephones. It's an earlier work from 1995. It's 7 minutes long, uses an archive of film clips from Hollywood films, and the theme here is the relationship of people to the telephone and the emotions they convey over the telephone. The clips themselves are on the order of 5 seconds, highly transformative, fair use. Now, let's turn to appropriation by kind of rote copying. This is an image from 24 Hour Psycho by Douglas Gordon, the well-known Scottish artist, created in 1993. It is, in fact, the famous 1960 Hitchcock masterpiece Psycho, prolonged, elongated to a full 24 hours. It was shown at the Hirshhorn earlier this year. Does the slowing down of this work, in fact, transform it? It's really a transformation of the experience of the work. To be sure, it was different from the original in that there was no audio track. Now, the law may, in fact, recognize that there are differences in the artwork itself based on the perspective and the perception of the viewers, how they experience the work. And, of course, in terms of the effect on the market for the work, no one who wants to rent Psycho this weekend for a Hollywood Halloween night viewing is in fact instead going to trot down to the local museum and sit through 24 hours of this movie to watch the shower scene. But Psycho, by the way, does seem to inspire, like Barbie, who we'll get to in a bit, appropriation over and over. Paul Pfeiffer created a work called Self-Portrait as Fountain. He takes the famous shower scene, he reproduces it in a whole bathroom with tiles, plastic curtain, running shower, no body, no blood. But he says everything is, this is Pfeiffer talking, everything is exactly what is in the film scene, minus the body or blood. But of course it is not exact. It is highly transformative. It's creating a three-dimensional installation from a two-dimensional image. And obviously that's the kind of transformation that the law should sanction, not condemn. It's another wonderful image from Psycho. Now, there is this kind of rote copying, if you will, with some transformative elements, even in painting to painting. This is a painting by Mike Bidlow, who makes full-size, faithful copies of paintings by Leger, Cézanne, Matisse, Pollock, Lichtenstein, Picasso. He attaches his signatures and renames them, in this case, not Leger. Now, to turn to another thread of this discussion, Duchamp, this image, allows me to linger for yet another moment on what sort of work is actually protected against appropriation. We saw earlier that the Brancusi was declared to be a work of art, and it would qualify for copyright protection. Copyright requires originality, but one question is how original does the work have to be? In the United States, the test of originality is minimal. Now, are the Duchamp ready-mades sufficiently original to be protected? Here we see his famous or infamous fountain. Does removing an object from its context and calling it art without more satisfy the requirements of artistic expression such that this is an original work of art, and therefore Duchamp, if he had been so inclined, could have prevented others from making copies of it by doing the same thing themselves? Unclear. What is clear is that Mike Bidlow, inspired by the Duchamp, made this work, which is 5,000 drawings made over a period of 5 years on the theme of Duchamp's urinal, and I would again argue that this is highly transformative. Now let's talk about something that is really rote copying. The quintessential postmodern appropriator, in some sense then, is Sherry Levine, who copied and did, frankly, not much more than copy an original photograph. Some of you may be familiar with this work, although what this work actually is probably unclear to you. Because in 1936, Walker Evans photographed the Burroughs, a family of sharecroppers in Depression-era Alabama. And in 1979, Sherry Levine rephotographed Walker Evans' photographs from the exhibition catalog, first and last. Is this it or not? Well, in fact, this is an image by the artist Michael Mandelberg, who created a website after Sherry Levine. And taking appropriation to the logical next step, of course, there is now a website after Michael Mandelberg. Let's talk about the special case of parody. It's a special type of appropriation, and it's classically considered to be a fair use. What is a parody? It is an appropriation that at least the Supreme Court has said needs to appropriate the work in order to lampoon or criticize it. The parody does not work unless the work itself is taken, and the Supreme Court, in sort of a bit of a literary leap, tried to distinguish satire from parody. Satire, it said, is using a work to make fun of something else, and satire is not as privileged as parody. Let's take this famous, at least to those of us practicing in the area, and somewhat humorous example to illustrate what we mean by parody. Once again, it is a photographer who is suing. Here the plaintiff is Annie Leibovitz. She sued, claiming that her famous photo of Demi Moore on the left was infringed by superimposing the head of the actor Leslie Nielsen on Moore's body. The purpose of the work on the right was to advertise the movie Naked Gun. Another 10 points for Columbia. But Leibovitz lost because the use was adjudged to be a parody, a fair use. And of course, that would be a parody, and Leonardo probably wouldn't have had much of a claim. And then we have this by Botero. I don't really want to focus on moral rights because I don't have the time to do it, but perhaps Leonardo might have had a claim against Duchamp and Botero for despoiling, dishonoring his famous work. It's a whole other category of legal doctrine that we don't have time to get into. Now, when we talk about fair use, we can't ignore the famous case decided some years back here in New York involving fair use and an asserted parody, which involved a media transformation and the artist Jeff Koons, who lost the case. There was a photographer, again, named Art Rogers, who took this photo of 8 German Shepherd puppies, which he licensed for use on note and postcards. He included a copyright notice on the back of the cards. Let's see, there we are. Jeff Koons, who is known for his appropriation, took the back of the postcard, removed the copyright notice, and sent it to fabricators for reproduction in 3-dimensional statute, telling them to copy it literally, although obviously he added color, and he put spots on the noses of the dogs, and he added some flowers in the hair of the people. But this is clearly a highly transformative work. You go from the photo to a sculpture. Rogers sued Koons and the gallery for $375,000 for infringement and $2.5 million in punitive damages. Koons argued for fair use. He provided expert testimony that the photo and the sculpture were extremely different. Well, duh, of course. The lower court held for Rogers, the plaintiff, the sculpture was an infringing derivative work, and he held that Koons must deliver the artist's proof to Rogers. On appeal, Koons, like any good artist, questioned how judges who have no training in art — this is not a winning argument, by the way, when you go before the court — can apply legal concept to an area they do not fully understand. He argued that the legal process itself had a chilling effect on creativity. The court acknowledged that he'd engaged in the practice of, quote, appropriation, but rejected his defense of fair use. They said it was not a parody because it did not comment on the, directly on the photo. Not sure about that, but it's clear to me that the court was influenced by what they regarded as 2 factors. One, Koons, they thought, acted in bad faith by ripping off the copyright notice and sending the postcard to his fabricators. And second, that there really was a sort of a fundamental income disparity going on here. That Rogers had been paid $200 for taking the photo, and that Koons was selling each of the, quote, original sculptures for several $100,000. Koons then was plain unlucky. He subsequently lost 2 other similar copyright cases. There is some question, though, whether this case is still good law in light of the Supreme Court decision subsequently on parody that I mentioned. Now, not all appropriation artists are as unfortunate as Koons. I said I would talk a little bit about Barbie. This one? Yeah, so the Second Circuit held that he did not engage in a fair use, and he was liable for copyright infringement. He had to pay out. Yeah, so he had to pay out. And as I said, in 2 other cases, he also lost. I mean, sort of unlucky in his art-making practice. I guess what happens if you become, kind of rich and famous, although as we'll see at the end, if you at least become famous and well known, that helps you in other contexts when we talk about the right of publicity. So it's anomalous in that regard. I promised you that I would talk a little bit about Barbie, who's perhaps our most famous cultural icon. And Mattel seems to lose every single case in which it sues someone for appropriation, either in a case that I'm now about to describe or in a case involving music that makes fun of Barbie. Thomas Forsyth's art, this is a Utah artist, we'll show it in a moment, in his series Food Chain Barbie, comments on Barbie. Here's Barbie, and there's some parodies of Barbie depicted nude in some vintage appliances. I don't know how many of you have seen this series. So this is an original. That, of course, is an original. And that is a parody. The Ninth Circuit held that Forsyth's use of the Barbie image was a fair use under copyright law because it was a parody, and furthermore that he could use the word Barbie in the title of the works, and that the classic Barbie trade dress, the kind of look and feel of how Barbie looks, could also be appropriated by the artist. There was no showing that Forsyth was undercutting the market for Barbie dolls. Well, again, obvious, right? No one is going to go and buy this for their child instead of the Barbie original. The court, in fact, was so upset with what it thought was Mattel's unreasonable position in trying to squelch artists' fair use of Barbie that it earlier this year awarded substantial attorney's fees to Forsyth, over $1 million. I don't want to spend a lot of time on the next image, except to say that sometimes copyright can be used in ways that are sort of politically significant, and some might say appropriate or nefarious, depending on where you stand. In particular, copyright played an important role in one of the significant battles of the culture wars involving the NEA and federal funding for the arts back in the 90s. Those of you who are students may not remember all of that, but in any event, Congress had passed a law restricting the type of projects that the NEA could fund. There's a very well-known artist named David Wojnarowicz, who in 1990 had a show at Illinois State University called Tongues of Flame, with a catalog, essays, and interviews. He made a lot of work, and this work was deemed offensive by the Reverend Donald Wildman, who may be known to you as the head of the American Family Association. He created a brochure that was essentially anti-NEA funding, and so then look at the DREC that your tax dollars are funding. And you can't really see this, it's a large work, but there are sort of sexually explicit images on the, I guess, lower right-hand side, maybe upper right-hand side. And then there's also this image on the right from another work that particularly offended Wildman because it shows Christ as a drug addict with a hypodermic needle in his arm. So Wojnarowicz was very upset by what he regarded as the misuse of his work of art, and he sued Wildman on a whole series of claims, including copyright, defamation, a violation of the New York Artist Rights Act, and basically he lost on the copyright claim. He won $1 for a violation of his moral rights, and the reason why he lost is because the court said, look, only a very little bit of this work was taken. It was for a highly political, critical purpose. And so this kind of appropriation for really criticism and commentary and for a larger political discourse was held to be a fair use. I want to turn now very quickly to two other legal doctrines that are implicated in appropriation. One is trademark, and the other is the right of publicity. The greatest, or at least among the best-known appropriation artists of the 20th century, of course, was Andy Warhol. He used images of Jackie, Marilyn, and of course, famously, Brillo boxes and Campbell soup cans. Trademark, in a nutshell, protects goodwill in symbols identifying goods and services. Virtually anything can be a trademark. Protection comes from use. Trademark is a source identifier. Where does the product come from? This can comes from Coca-Cola, or this bottle comes from Pepsi-Cola. The key to trademark law is that it is designed to prevent consumer confusion. So a use of a famous trademark might in fact be permitted if there's no actual or likely confusion in connection with a purchasing decision, or there's no intent to confuse. I'm collapsing this strand of trademark law for these purposes. But in general, parody or other artistic comment is permitted. There's a First Amendment right to comment on trademark product, and appropriation of the mark may be permissible if no consumer confusion. This is relevant to those of you who saw Joy's talk, because in the image of the Molotov bomb thrower, there is a bottle of Pepsi, and there was a lot of chit-chat on the website that in fact she'd been threatened not by the photojournalist, but threatened by Pepsi itself. That wasn't true, and in fact, it seems to me quite clear that Pepsi would not have had much of a legal leg to stand on. But let's consider this image, or this image, obviously iconic images. Warhol did not seek permission from Campbell's Soup. The company purportedly was amused by his usage and presumably did not want to interfere with the artist's freedom of expression. So he retained the copyright in the image. Now, after his death, the Warhol Foundation began entering into license arrangements with various manufacturers to use his images on their products. Now, at that time, at the time that there was a commercial use being made of these images, the Foundation and Campbell's entered into a licensing arrangement. Both parties control the copyrighted images, and neither can make licensing arrangements without the other. So the irony, of course, here is that today artists cannot appropriate these Warhol images of famous soup cans, unlike Warhol's own artistic practice, unless they do so as a kind of fair use. Now, as I said several times earlier, artists today often appropriate iconic images of real live people. Warhol himself was sued in 1996 for copyright infringement by the life photographer of the photo of Jackie that he used here. He was not sued by Jackie's estate. And in general, Warhol, I think it's fair to say, never got permission from the people whose images he used. Now, after the fact, the Warhol Foundation sought to commercialize these images, and then it did obtain permission from the photographers. This brings us to another area then where the open source artist who uses cultural icons can collide with a different set of rights arising out of the so-called right of publicity. We've seen this kind of use of cultural icons in the work of Pfeiffer and Markley so far, and Warhol's use is obviously well known. Again, law in a nutshell, right of publicity contemplates the notion that celebrities have a right in their personhood. They have a right to commercial exploitation of their likeness or their name or their voice. This is a state law right, unlike copyright and trademark, which are essentially federal law, although there can be some trademark rights at the state level. Publicity rights generally do not endure indefinitely beyond death. Here in New York, they expire with the death of the celebrity. And there's a sort of fundamental tension between the First Amendment right of the artist to use these images and the right of publicity. And we'll see a couple of cases that have tried to harmonize the First Amendment with the right of publicity. And this is one case, very famous case, where Dustin Hoffman sued Los Angeles Magazine and its publisher for a violation of his right of publicity under California law. The magazine had run a story using computer-altered stills from famous movies to make it seem that the actors, most of whom were long deceased, were wearing the newest spring fashions. I don't have to ask you what movie this is because it says right there. This image on the right shows Hoffman in an evening dress and high heels, and in the computer-altered still, his body was replaced digitally, as an artist might do today. In this case, it was a Los Angeles Magazine, with that of a male model wearing items of current designer fashion. Hoffman had not given his permission. The trial court found that Hoffman's right of publicity had been violated and awarded him substantial damages, about $3 million. That was overturned, though, by the Court of Appeals, which held that the models were deceased, generally, and the language made it clear that the body really wasn't that of Hoffman, but was of a digital manipulation. So in this case, the First Amendment won. Now here's an artist who those of you who are at Columbia may not be intimately familiar with. It's an artist, Rick Rush, who paints famous sports figures in historic sporting events. This is entitled The Masters of Augusta, commemorating Tiger Woods' historic 1997 victory of the Masters tournament. Tiger Woods didn't give his permission to make this image, sued on trademark, false endorsement, and right of publicity ground. The district court, the lower court, found that this was artistic expression seeking to express a message, and the First Amendment protected it. Last year, I think it was, the Sixth Circuit affirmed this decision and said that Wood's right of publicity were not violated because this work is highly transformative and has substantial informational and creative content. Here, Rush has added a creative component of his own to Wood's identity, and permitting Wood's right of publicity to trump Rush's right of freedom of expression would extinguish his right to profit from the creative enterprise. And we conclude that society's rights outweigh Tiger Woods' personal rights. So that's really a very good decision for all sorts of appropriation artists. But then we have this decision. And there's a decision I'm about to describe involving these images. The California Supreme Court held in a case brought by the owner of rights to the Three Stooges that an artist who basically made images that look like this — I don't actually have the Three Stooges image for perhaps reasons that will become obvious — that this artist was not protected by the First Amendment, because in this case they said that the work was not sufficiently transformative. It basically was work that tried to reflect the actual likeness of the celebrity, but did not have some sort of artistic inspiration independent of that likeness. Kind of a dangerous test, if you ask me. They said there was no significant transformative or creative contribution. It was, quote, conventional, and people were buying the work because it showed the Three Stooges, not because it was a work by, in this case, the artist Gary Sadarup, who is probably unknown to most of us. So the teaching of this case may be, if you're famous or the work is highly transformative, you've got a First Amendment right, but if you're less famous or your work is closer to the likeness, you don't. And indeed, the judges went on to say, talking about Warhol, even though he wasn't really directly involved in the case, well, of course, Andy Warhol conveys a message that goes beyond the mere commercial exploitation of celebrity images, and it's a form of ironic social comment on the dehumanization of celebrity itself. It's a wonderful kind of art historical comment by the justices of the California Supreme Court, but it advantages Warhol over poor Mr. Sadarup. So is it fair that Warhol is protected because he's better known, because he's arguably more talented, because the work is more transformative? Is that really fair? And won't this in some measure come down to courts imposing their own artistic judgments on their preferences for particular types or styles of work without really valuing the appropriation artist's contribution to larger artistic and social discourse? And now, just to wrap up, I want to spend a couple of minutes on another class of repurposing of art, which is very much on my mind in my capacity as counsel to the College Art Association. This is art publishing, particularly in a critical context, whether in online journals or in hard copy journals, or hard copy journals that eventually find their way to electronic media. Usually, when you're a publisher, you ask that the contributor clears the rights in the artwork or photograph that accompanies the article. This can be problematic for the contributor because sometimes it's difficult to clear the rights. More often than not, the author is required to indemnify the publisher if the rights in photographs and artworks that accompany the article are not cleared. And most essayists, scholars, contributors to journals really don't have much of the wherewithal to, in fact, make their indemnity worth the paper that it's printed on. If the rights aren't cleared, then the publisher and author can be sued for copyright infringement unless there is some sort of argument of fair use. Now here I want to talk a little bit about the case of the Bridgman Art Library. I had promised that earlier. There is a case that stands for the proposition that the photographs of two-dimensional works in the public domain are not themselves copyrightable. So remember what I said earlier, that most photographs are copyrightable. Well, there is a case that says that if only technical skill is involved in the making of the photograph, then there is not enough sort of creativity or artistic expression to protect the photograph. And so the court says in a case which holds that you can't get protection for slides that are absolute faithful reproductions of a public domain work, where the court says transparencies here, these were slides, stand in the same relation to the original works of art as a photocopy stands to a page of typescript, a doodle, or a Michelangelo drawing. Well, maybe that means that Sherry Levine's work is not independently copyrightable because she was in fact trying to make a slavish reproduction of some underlying work, leaving aside that that work was probably not in the public domain, the Walker-Evans work. So that's perhaps a troubling decision for some kinds of artists who may be using technical skill, mere technical skill, as opposed to artistic expression. But it's a great decision for art publishers and essayists and others who want to use photographs of works that are in the public domain, a photograph taken by somebody of the Sistine Chapel or the Mona Lisa. Let's talk a little bit then about sort of fair use and how that operates if you're a publisher. It may be the case that publishers are unwilling to rely on fair use due to its uncertainty. Fair use is not certain in its application, as I hope you will have gleaned from the last hour, because it depends on how courts weigh these factors, and publishers may want some higher degree of certainty, which is really impossible in the world of copyright. So they rely on fair use and risk getting sued, or they ask permission and get turned down, or what we find is the potential of authorial self-censorship. Basically, authors increasingly may only be using images that can be cleared or that are in the public domain, government-commissioned images, which means that the world of images that can be used to tell our collective story that are still in copyright may not be used. And that, of course, is a troubling development for scholars as well as for publishers. This does highlight the importance, though, of the Creative Commons and other initiatives to try to put more work into the public domain or make the work freely licensed. But that's still a fairly nascent, though very important, undertaking. But it also underscores the importance of the whole get a license view of the world. Because if you always have to get a license and you can't find the artist or the photographer who's made the work that's being used in an art journal, you basically have to decide to risk a fair use call or not publish. This is particularly the case with respect to electronic publishing. Publishers today either are beginning born native electronic publications or are taking hard copy publications and putting them onto websites or making them available through electronic databases. And increasingly it's getting harder and harder to get permission from third parties who own underlying images, photographs, or works of contemporary art, because they are concerned that the works will appear on the internet. Well, as this presentation has made clear, it is very easy to take a work that appears on the internet and put it into your PowerPoint presentation. And that's for a legitimate fair use, right? But you could imagine much more nefarious uses of some of the images that I've shown you today. So third parties may be prohibiting electronic dissemination, which is hard going if you're a publisher who then wants to put your work on some electronic database or distribute it somehow through CD-ROM. The rights holders may be insisting that the electronic rights can only be available for a limited time. They'll say, we'll give you a license for 2 years. Well, what happens at the end of the 2 years? You have to go back and get a license for all of the images that are in your publication? I don't think so. Or they may be charging higher licensing fees for electronic distribution. It's one thing if you're a very wealthy publisher, but if you're a scholarly publisher, you're an academic publisher, the licensing fees may in fact make it prohibitive to publish works that are still in copyright. So there are no obvious solutions here. Maybe image rights owners will feel their concerns mitigated somehow through the use of digital rights management technologies, watermarking, encryption. But there are problems with that too, because it may interfere with fair use, the ability to use an image that is protected by digital rights management for a perfectly legitimate purpose. Another possibility is that publishers might be more assertive in determining when they have a fair use right to use the images. And they may actually start indicating in publications when they are invoking the fair use doctrine. Right now, you look at a publication, it never says authorized under the fair use doctrine. But maybe publishers should start doing something like that. Or this work is in the public domain, and therefore we have every right to use it. Essentially bringing to the forefront this notion of fair use, public domain, and the ability to use images that are not within the exclusive rights of the copyright owners. And that's a solution that I'm working on today with a number of art publishers. So I think what we've learned, or at least I've learned, is that an open source art-making culture can in fact pose challenges to the law. There's in fact quite a lot of rhetoric in law journals, on the websites, listservs about appropriation leading to the demise of copyright, for example. I think, frankly, that that's overstated, that the worlds of the law and the worlds of art making can coexist, and they need not be in inevitable collision. I mean, sure, there will be problems that arise from time to time, but I think the vast majority of artists who are engaged in legitimate art-making enterprises through appropriation will be let alone. And with those somewhat reassuring words, I will stop talking. Thank you. I guess now I open myself up to questions, if any. Or if you're all stupefied, we can all go and have dinner. Yes, and could you speak loudly?
Sure. When you were talking about the museum ownership, like Ringo and the High Museum, and that the quilt, I guess, did HBO ask the High Museum if they could use the image yet because they didn't ask the artist? I mean, did the museum own the piece? Even though they own the piece, they still have to get permission of the artist?
Yes, and I think I tried to. The question is, if the museum owns the piece, does the museum control the copyright rights?
Right.
And I don't actually happen to know in that case, but since Ringgold brought suit, I would have said that Ringgold was the copyright owner. It would be highly unusual that the museum would have had the exclusive rights in the copyright or would have actually been assigned the copyright, which is the condition predicate to bringing suit. So I think in almost every case, you'd have to go ask the artist or a collective licensing society for the artist like VAGA or ARS. And so I think what happened in this case was the producers of the television program thought it was a, quote, de minimis use. In the backdrop, could only see for a few seconds, 26 seconds, never really saw the entirety of the quilt. It was a little vague, a little indistinct. And so I'm sure the producers didn't think to ask, or if they did, they thought they didn't need to ask. Since I also represent major commercial copyright owners, shall we say, I know it is now standard practice, particularly among the major motion picture studios, that that sort of thing doesn't happen again. Now, everything is cleared, or virtually everything is cleared, and it's highly unlikely that that sort of case would be brought today. There are many other cases, though, that are of great and equal interest. Some of you may know that my firm was involved in defending Sony Pictures in a case involving the first Spider-Man movie. The owner of the buildings on which 2 billboards in Times Square was affixed sued Sony Pictures because there is a scene in the first Spider-Man movie where sort of the Green Goblin and Spider-Man are fighting at the World Unity Festival over a fictitious, highly digitalized image of Times Square. The building owner brought suit not for copyright infringement, but for trademark infringement, and lost. We argued there was a First Amendment right to make a movie. We said, guess what, judges? The whole movie is fictional. There is no real Spider-Man, and therefore no one should really think that this was an actual representation of the real Times Square. That plays into what my prior response by saying that in general there is very sophisticated rights clearance going on now for most major motion picture studios and television producers, and so I think the Ringgold case is not a case that's likely to be brought again. Yes? That's a very good question. The question is, why would Happy Birthday in the movie The Corporation not be a transformative use? Well, it would be transformative in the sense of recontextualization, except that songs are always being recontextualized. I mean, a song doesn't basically exist outside of some context. I mean, it existed, I guess, in sheet music, but it either exists in a sound recording or it's being sung in a public place or in a shower. And so the rights that the copyright owner has, as I said, are to authorize the public performance of the song. The courts have held, and the law provides, that the reproduction of a song in an audiovisual work where the audiovisual work is shown in a public place is the public performance of the song, and that's within the exclusive rights of the copyright owner. But making movies such as that is, in fact, a very complex undertaking with an enormous amount of rights clearance. Another matter in which I was involved in arises out of a documentary some of you may have heard of called Outfoxed. This is a movie by a liberal, shall we say, documentary producer about Fox News. And it takes many, dozens and dozens and dozens of clips of Fox News programs and sort of combines them into what is a really very interesting documentary about Fox News programs. No permission was sought because none would have been given. And the producer was represented very ably by Larry Lessig and the Stanford Law School Clinic. And I think they concluded that those uses, which were samples, short samples in some cases, but in some cases went on for several minutes, were legitimate fair uses. And I think that's a very important precedent for all of us as well, because this was a case that was in the spotlight. Everyone understood what was going on here. It was clear taking, sampling of highly public works to make a new, transformative, recontextualized work. Well, essentially not unlike the Christian Marclay video quartet. And it stands for the proposition that that kind of activity, I think, is a legitimate fair use. But no, because it was used for criticism, scholarship, because you weren't taking very much of the work. Some clips were a second or so long. And obviously, there was no undercutting of the market for the original. Indeed, very few people, I suspect, watching Outfoxed would have regarded that as an adequate substitute for Bill O'Reilly.
I wasn't totally clear about your position or what you thought about the rights to publicity situation with the Maryland sketch that was perfectly technically reproducing,
Right.
as opposed to the other ones that were artistically modifying it. I guess my question is, do you feel that the person doing the technical sketch of her should deserve the rights? I mean, is it a legitimate worry that courts will end up only siding with artistic uses of celebrity images, or does it not matter?
Anyway, it's a good question. Sort of, what do I think about the right of publicity and how it plays out with respect to Andy Warhol on the one hand and Gary Satarup on the other? And I simply raise the issue to focus you on the fact that courts are making artistic judgments all the time, and maybe making judgments with respect to the quality of the artist, the fame of the artist, and as to the downstream use of the work. I mean, there's a kind of judicial cum artistic elitism going on here, that Andy Warhol was selling his artwork in lithos, they hang in museums, and Gary Satarup, whatever you think of his artwork, was selling it on t-shirts and fairly cheap reproductions and the like. And so one is art and one isn't. And I tried to suggest throughout the talk that context may really be quite important. Do you see a work in an art gallery, or do you just buy it off the back of a turnip truck or on eBay and put it onto your DVD? And so these are factors that judges are having to face all the time. We may all, those of us who are artists, may feel a little bit smug. We'll say, well, we're never going to be merely making likenesses for raw commercial purposes and selling them on keychains like Gary Satarup. But what does that say about sort of the appropriation artist who, in fact, is in the business of making money and selling images that she makes? So I'm still not sure how I come out on that, but I do note that there is a kind of elitist aesthetic that's permeating sort of the judicial doctrine in this area. Yes.
I thought I heard you say that mere pictures of great work of old works of art can be copied themselves can't be copyrighted. Does that mean that it's open game for all art books of collections and all the web pages with pictures of old masters? And how old is old?
Yeah, it's a brilliant question, and it's something that it's something I deal with every day, and I'm joined in the front row here by Yves Senaiko, who's the director of publications at the College Art Association, who grapples with this issue every day. So let's start with the easy part of it. Old means anything that's in the public domain. So there's a very complex calculation to determine what is in the public domain. In general, works created before 1923 in the United States would be in the public domain, but there are works created after that date that would be in the public domain. Second, yes, it has very profound implications for people who are asserting copyright over digital images or slides of public domain work. Up until this decision, the Bridgman decision, museums and many others, art slides purveyors, were asserting copyright in the photograph of the public domain work. So their photo of the Mona Lisa was in copyright. And as I said at the very beginning, photographs historically are subject to copyright. This decision suggests that if you're basically making a slavish, technically perfect reproduction of the underlying public domain work, you cannot assert copyright. Now, you could assert some kind of contractual right. I own the slide, I give you the slide only if you sign a contract that says I'll never use it except for showing it in the classroom. If the individual then takes the image on the slide and uses it in an art book or puts it on a website, you have a breach of contract action, but you don't have a copyright infringement action. Now, I need to say about that case was decided here in New York by a single district judge. So in point of fact, in pure legal sense, only is binding or has application actually in Manhattan. But no other court has come out any other way, and it is a kind of precedent that at least people in their artistic publishing practices are following. Yes, sir?
I think Joy mentioned last time that, for example, Adam Ansell's painting, photograph of the mountain, the photograph itself was copyrighted, although anyone could take another picture of the mountain. I'm wondering if that plays into the description you just made of a technically precise work of something that's in the public domain, or if you want to clarify a little more what you meant by that.
Yeah, so obviously there's no difference between a mountain and an old master painting from what I've just said. They're both in the public domain. But the difference that the court was drawing was between mere technical skill in making a sort of faithful reproduction of a work and the kind of artistic inspiration that we would see in Ansel, Adams, or any other very, very famous photographer, whether it's Avedon or Cartier-Bresson. And I think the view is that all of those people were doing quite a lot in terms of lighting, composition, the moment, and that the skill being deployed and displayed by these world-famous photographers is quintessential creative artistic expression. As is, by the way, you standing at the foot of Manhattan and taking a picture of the Statue of Liberty, unless you're a world-famous photographer yourself, you would be in a different category, except that what you're doing is displaying some sort of artistic innovation and creativity, even though that picture may be taken 4 billion times. Your work is protected by copyright. And so there's a little bit of a danger from the copyright owner's perspective in the implications of this decision. Where does creativity stop and technical skill pick up, or the other way around? Sherry Levine, when she's photographing the image of the Walker Evans photo, is in fact engaged in a very slavish reproduction of the underlying work. It may suggest that there is nothing more than mere technical skill involved in what she's doing. Therefore, her work is purely in the public domain. There is no copyright, leaving aside that she was infringing copyright. But if she had been, let's say, taking that kind of an photograph of a 19th century print, somebody very well could say that even though it's by Sherry Levine and is famous, therefore, it is not protected by copyright.
This may be too broad a question, but I would appreciate any comments you had. I was wondering about this law more in the international context. Not so much, I'm sure different countries have different laws, but
an excellent question. The question is essentially the relationship between international practice and domestic practice, particularly for museums, and whether the United States is leading the way. There are a few things to be said. First, intellectual property laws are territorial. So each country, as you said, has its own law. Cases are only applicable within the boundaries of the country. There are no international bodies that are trying to standardize legal principles in this area, except that there are regional groupings like the European Community that have come out with something called the Copyright Directive that's trying to harmonize the copyright laws among the members of the European Union. There are groups that are focusing on this, and I've given talks to museum organizations where people are engaged in the study of contemporary art practice, in particular how works get displayed in museums. Can you take a new media work and show it in a museum in a way that's different from the artist's original artistic intent? The artist gives it to the museum, it's on VHS, can you copy it, put it on DVD and show it on, on a DVD player, that sort of thing. But with respect to the United States taking the lead, I think it is fair to say, first, that there are many more cases that arise in this area in the United States. That's true in virtually every area of the law. It's certainly true in intellectual property law. It's absolutely true in the case of the intersection of new digital technologies and intellectual property law. Second, we have far and away the most robust fair use doctrine. We're the only country that has a, quote, fair use doctrine. So other countries, generally speaking, are much more protective of the artist than, that is to say, the original artist, the copyright owner, than we are. We take these 4 fair use factors and we take them seriously. Obviously, Cunard lost a case and Universal lost the case involving 12 Monkeys. But in general, we take the fair use doctrine quite seriously, even though it is vague and uncertain in its application. Other countries don't have as kind of a robust set of exceptions to the rights of the copyright owner. So this is basically a better place in that sense to be if you're an appropriation artist. What's extremely important, though, and it's a subject for a whole other talk, if I'm ever invited back I may give it, on what about art that is kind of made internationally and inherently distributed internationally. So if you're a net-based artist and your work is created through a consortium of artists working in a number of different cultures, and your work is accessible everywhere in the world because it's posted on a website, you then in fact do have to start paying attention to the laws of countries outside the United States, because you may be infringing rights in that country even though what you may be doing in the United States is protected under the fair use doctrine. But that, as I say, is a subject for another day. All right? Thank you very much.